Good day, everyone. My name is Jessie Justin Sampang, and we are the Group 3. So for today's chapter, we are going to discuss Chapter 7, which is the Labor Law Management and Tourism Establishment. Introduction. This is an overview of the Philippine labor law in the hospitality and tourism industry. The law will be determined the civil right of the individual workforce of the industry. This will be the protection ground of the worker once they enter in the field industry as tool guide or materials, also for the future business in hospitality and tourism industry. One of the most important laws which any industry practitioners must know is the Labor Code. Labor Code is a set of laws or regulation that govern the relationship between employers and employees in a particular jurisdiction. So the company should possess at least basic knowledge about this law to prevent legal disputes among its employees. Similarly, employees in tourism establishment should also be familiar with this law to safeguard themselves against potential abuse and unlawful practices by employers, particularly concerning benefits rights and job security. Now let's talk about the concept of employer and employee relationship. The employer and employee relationship is the heart of any organization, and it's more than job titles and paychecks. It's the give and take between employees and employers. So ayun, madami sa mga employer dito sa Pilipinas is lumalayo sa mga employees nila kasi para walang confusion kung sino yung mas nakakataas sa kanila. But some of the employer naman dito sa Pilipinas is mas nagiging friendly sila sa mga nakakasalamuhang employees nila para syempre mas magaan yung nararamdaman ng mga employees kung ano yung pinapagawa sa kanila. So generally, employer and employees relationship should be mutually respectful. So yung mga employees, sila yung nagko-contribute ng skills and effort, while the employers naman sila yung nagpo-provide ng opportunities and support. So dapat si employer is maganda ang pakikisama niya or pakikisalamuhan niya kay employee para maganda din ang mga pinapagawa ni employer kay employees. So sabi nga nila, it's like a dance. Where both partners work together to create harmonious and productive workplace, diba? So the relationship between those two is very important to form mutual respect, trust, and appreciation. So there are fourfold tests to determine whether an employer and employee relationship exists. The first one is the selection and engagement of the employee. The second one is the payment of wages. The third one is the power of dismissal and the employer's power to control the employee's conduct the control test. So there are kinds of employments, which are the regular employment, casual employment, project employment, seasonal employment, fixed period employment, and probationary employment. So now let's discuss first the regular employment. It involves the employee's commitment to fulfilling assigned duties and the employer's obligation to provide a conducive work environment and fair enumeration. So who is the regular employee? So those who are engaged to perform activities that are necessarily or desirable in the usual trade or business of the employer, or a casual employee who has rendered at least 1 year of service, whether a continuous or broken, with respect to the activity in which he is employed. In addition, according to Article 2 of Labor Code, an employee who is allowed to work after a probationary period becomes a regular employee. So it is the natural of the activity that determines whether employment is regular or casual. This means whether a job is considered a regular or casual depends on the task involved and their importance to the business, not just what the employer says. It's about what you actually do and how essential it is to the company. So the next one is the casual employment. So those are the employees who are hired as needed, and these positions are often temporary or short-term. So casual employees are offered different benefits and job security than full-time or part-time employees. One of an example of casual employment could be a restaurant hiring a band or a musician to play background music for a special event. The musician's performance is not essential to primary functions of the restaurant like serving food, listing menus, but it adds to the atmosphere and customer experience for the particular event. A casual employment may become a regular. One of the examples of this is a construction worker hiring for a building construction of the project. Initially, he may be considered as casual due to the temporary nature of the project. But however, if after 1 year and he still continued to work on the same project or offer projects for the same company, he may be deemed a regular employee under Article of 280 of the Labor Code of the Philippines. His work as a construction worker will be considered regular as long as the activity persists. So the next one is the project employment. It is defined when an employee is hired for a specific project or undertaking, and the employment duration is specified by the scope of work and or length of the project. A project employee may acquire the status of a regular employee when they are continuously rehired after the completion of the project, or when the tasks they perform are vital, necessary, and indispensable to the usual business or trade of the employer. So one of the example of project employment is your organization needs a new website, and you will need to hire software developer, programmer, writer, and etc. So, matatapos lang yung kontrata nila kapag natapos na nila yung project na pinapagawa sa kanila. So, the next one is the fixed-term employment. So, fixed-term employment refers to a type of employment that has specified start and end date, where an employee agrees to work until the end of the date or at the completion of a project. So, one of the example nito is yung mga employees na nag-maternity leave. And then, ang mga papalit sa kanila is yung mga fixed-term employees hanggang sa bumalik na ulit yung dating employees. So, tawag sa kanila is fixed-term employees. So, the last one is the probationary employment. So, it is an employment arrangement between the employer and the probationary employees, wherein the latter will be required to undergo probation to determine their fitness for regular employment. The probationary employment should not be exceed 180 calendar days. So, kapag nag-exceed na yung 180 days at still working pa din si employee, he may be considered as regular employee. So, sila yung mga newly hired employees na still binabantayan pa din kung sila ba ay suit sa isang kumpanya or hindi.
Casual employment. Ito daw po yung mga irregular and regular employee na hindi magkapares ng benefits. Like katulad ng irregular employee is wala silang SSS or Pag-ibig or PhilHealth, di katulad ng mga regular employees. Casual employee may be regularized. According to Article 295 of the Labor Code of the Philippines states that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, a casual employee with less than 1 year of service is not a regular employee. Yung mga irregular employee daw po, yun yung mga hindi pa umaabot ng 1 taon sa trabaho nila. And yung mga regular employee naman po, yun yung mga umabot na ng 1 taon or higit pa dun sa trabaho nila. Project employment. Ito daw po yung mga employer na magbibigay sa'yo ng mga project na alam nilang kaya mong gawin para mas maging maganda or mabilis yung outcome ng project na ibinigay sa'yo. Two requirements may be satisfied to remove the engagement from the presumption of regularity of employment. First, designation of specific project or understanding for which the employee is hired. Ito daw yung mga binigay ng employer dun sa employee ng mga specific job or task. Kung ma-hire ba sila, kung natama ba nila or na-accomplish nila ng tama yung specific job or task na binigay sa kanila. Second is the determination of the completion or termination of the project at the time of the employee's engagement. Ito daw yung pagko-compile ng mga specific job or task na binigay sa'yo ng employer mo dun sa time na binigay sa'yo or nakapagkasunduan yung 2 oras.
Seasonal employment. Ang example ko po dito is merong mga company na tumatanggap sila ng full-time, part-time, or taon sa mga employees na gustong pumasok sa isang company. Fixed term employment. Ito yung example ko dito is ito yung mga employee na kung pumasok sila sa isang company na kontrata yung kanilang ipapasok doon sa company. At kung aalis naman sila sa company yun, is kailangan nila tapusin yung kanilang kontrata na pinagkasunduan niyang company. Dito naman sa seafers or contractual employees, yung mga katulad ng mga mandaragat or magbabangka, these are tinutuloy regular employees under the Article 280 of the Labor Code. Their employment is covered by the contract they sign every time they are hired, and their employment is determined when the contract expires.
Probationary employment. Sa probationary employment, ang isang empleyado ay sumasailalim sa isang trial period o yung panahon na pagsubok sa simula ng kanyang trabaho. Sa panahon ito, sinusubukan ng kanyang employer ang kanyang kakayahan at angkop siya para sa regular na trabaho. Dapat na ipinalam sa empleyado ang mga reasonable standards o yung mga katanggap-tanggap na pamantayan para sa kanyang trabaho. For example, si Marco ay in-employ bilang isang probationary employee sa isang kumpanya. Sa loob ng 3 buwan ng kanyang probationary period, susubukan siya ng kanyang employer kung paano niya ginagampanan ang kanyang mga tungkulin at kung tama siya para sa posisyon. At bago siya nagsimula ay ipinalam sa kanya ang mga pamantayan na kailangang matupad para sa kumpanya. Period of probationary employment. Ang karaniwang panahon ng probationary employment ay hanggang 6 na buwan. Gayunpaman, may mga exception sa panahon ng probationary period. Depende sa kasunduan ng mga partido, patakaran ng kumpanya, o kung ito ay kinakailangan ng trabaho. For example, sa isang kumpanya, ang probationary period ng mga bagong empleyado ay 6 na buwan. Ngunit para sa mga trabahong technical, maaaring paluwigin ang mga panahon ng probationary period upang masubukan ang kasanayan ng empleyado. Extension of probationary period is allowed. Ang pagpapalawig ng ang probationary period ay nagbibigay sa empleyado ng pangalawang pagkakataon upang patunayan ang kanyang kakayahan bilang isang empleyado. Ito ay isang pagpapakita ng kabaitan mula sa kanyang employer. For example, si Francis ay hindi nakapasa sa kanyang probationary period sa unang pagkakataon. Sa halip na tanggalin siya, nagbigay ang kanyang employer ng pagkakataon na mag-extend ng kanyang probationary period para magkaroon siya ng dagdag na panahon upang patunayan ang kanyang kakayahan. Hotel system of double probation is not allowed. Ang sistema ng double probation tulad ng sa mga hotel ay hindi pinapayagan. Ito ay isang transparent scheme na nalikha upang iwasan ang utos ng batas at gawing madali para sa kumpanya na tanggalin ang mga empleyado kahit pasado na sila sa probation. For example, sa isang hotel, ang isang empleyado ay sumasailalim na sa 6 na buwang probationary period. Pagkatapos nito, sinabi sa kanya na kailangan pa niyang dumaan sa karagdagang 6 na buwan na probationary period bago siya maging regular na empleyado. Ito ay isang halimbawa ng double probation system na labag sa batas.
Management prerogatives and fraud or willful. Management prerogatives. It refers to the rights and authority of managers to make decisions necessary for running a business. Now, this includes hiring and firing employees, assigning tasks, enforcing disciplines, making operational decisions, formulating policies, ensuring the workplace safety, setting strategic directions, and managing organizational changes. While these prerogatives allows for effective business administrations, they are subject to limitations imposed by the labor laws, regulations, and negotiated agreements with employees or unions. Balancing these prerogatives with employees' rights is crucial for a harmonious and productive workplace. Termination by employer. Just cause in terminating by serious misconduct and insubordination. So, serious misconduct, it involves severe behavior justifying immediate dismissal, such as theft, violence, growth, negligence, substance abuse at work, safety violations, and harassments. While the insubordination is the refusal to obey legitimate orders from a supervisor, including refusing tasks, showing disrespect, ignoring the policies, or undermining authority. While this both can lead to a disciplinary actions, serious misconduct typically warrants more immediate and severe consequences like summary dismissal. So, ayun, yung serious misconduct is, ito yung mga malalaking kasalanan, parang kunyari ng theft, yan, yung mga violence, safety violations, harassments, ayan. So, sila yung parang, agad, warrants agad, and like, dismissal, warrants, bibigyan ka ng warrants, or may dismissal ka. Or in subordinations, it might result in warning or progressive disciplines. So, yung sa insubordination, so ito yung mga, maliliit lang na actions na nagawa mo, na hindi naman big deal sa, big deal siya, pero maliit lang na showing disrespect, ignoring the policy. So, ayun, magkakaroon ka lang ng warnings, lalo na sa ignoring the policies. So, yun. Proper handling and documentation of these issues are crucial for maintaining fairness and compliance with employment laws. So, ito yung pinaka kailangan pag nasa isang company ka. So, kailangan maging fair sa lahat. So, kaya may dismissal, may mga consequences na kapalit yung mga nagawa mong actions. So, dapat ready ka, or dapat maging maingat ka sa mga actions na ginagawa mo pag nasa isang company ka na. So, next is the gross habitual neglect by an employee of their duties. It refers to a pattern of continuous and severe disregard for job responsibilities and expectations. This behavior goes beyond occasional mistakes or minor lapses. It is characterized by a persistent failure to perform the essential tasks, which significantly impacts the organizations. Example nito is yung missing deadlines, failing to attend mandatory meetings, ignoring safety protocols, or repeatedly delivering substandard work despite feedback and interventions. So, addressing gross habitual neglect typically involves disciplinary actions, which can range from formal warnings to termination of employment. It depends on the severity and persistence of the neglect or your actions. So, fraud or willful breach by an employee of the trust reposed. This refers to a deliberate action taken by the employee to deceive or betray the trust placed in them by their employer. So, ito yung, kunwari, mag-work ka na, then you have the employer. So, lahat ng trust, yung employer mo is, syempre, malaki yung trust niya sa'yo. Kasi parang hindi niya maayos ka ganyan. So, lahat ng employer is ganun sa kanilang client. This breach of trust can take various forms and is characterized by intentional misconduct or personal gain or to harm the employer. Example nito is yung mga
gagawin mo sa company na pinasukan mo yung embezzlement, forgery, unauthorized disclosure of confidential information, or the intentionally sabotaging company operations. So, ayun. Employers typically respond to fraud or willful breaches of trust with swift and decisive actions, which may include termination of employment, legal action, and efforts to recover damage. Preventative measures such as robust internal control, regular audits, and thorough background checks can help mitigate the risk of fraud and protect the organization's interests. So bago tayo mag-hire ng tao, so kailangan natin munang i-check yung backgrounds nila para mas makaiwas tayo sa ganung tao na is sasabotage yung company, if forgery, unauthorized disclosure of confidential information, yung ilalabas yung information ng ibang tao na nasa company din. Yes, this will protect the organization's interest. So, next is the commission of a crime or defense by the employee against the person. This refers to the situation where an employee engages in criminal behavior or self-defense actions that involves another individual. This could occur within or outside the workplace and have been serious legal and employment consequences. So, ito yung essential for employers to have clear policies and procedures in place to address such situations, including the reporting mechanisms, employee assistance programs, and training on conflict resolution and workplace safety. So, additionally, employers should ensure compliance with relevant laws and regulations governing workplace and behavior safety. So, isa sa pinaka-essential na bilang employer to have na magkaroon ka ng clear policies and procedures in place to address such situations para maiwasan din siya, and kung iba minsan may behavior sila na hindi maganda or may pwede silang gawin. So it is essential for employers to have clear policies and procedures in place to address such situations, including the reporting mechanism, employee assistance, etc. Serious misconduct. It is a severe behavior by an employee that breaches employment term and justifies immediate dismissal. So ito yung mga kailangan ng tanggalin sa position. Example is yung kagaya ng kanina is example nito is yung theft, fraud, violence, threats, abuse, harassment, discriminations, and such. Actions undermine trust and employment relationships, often leading to a summary dismissal after a thorough investigation to ensure fairness and legal compliance. So, para walang madamay, so the HR would do a investigation sa nangyari para magkaroon ng fairness and legal compliance. So, it must be serious, it must be relate to the performance of the employee's duties, and must show that the employee has become unfit to continue working for the employer. So, ayun, kailangan itong investigation na ito, it must be serious, it must be relate to the performance of the employees. And it must show that the employee has become unfit to continue working for the employer. Cases of serious misconduct. Assaulting a co-employee resulting to a fight between the two inside the residence where they work for and duty there. By the way, the cases of serious misconduct is ito yung mga na-encounter ng mga nasa company na nagtatrabaho sa restaurants. So, number 1 is assaulting a co-employee resulting to a fight between the two inside the residence where they work and during their duty. Next is employee may be validly dismissed for violation of reasonable company rule or regulations adopted for the conduct of the company's business. So, ayun, dapat ito yung employee na hindi niya sinusunod yung rules and regulations ng company. Or nag-violate siya sa mga rules. Number 3, an employee who was caught using prohibited drugs and within the company premises. So, ayun, yung mga employee na gumagamit ng mga drugs, ng mga pinagbabawal na gamot sa loob ng company. So, willful disobedience of the lawful orders or insubordination. One of the fundamental duties of an employee is to obey all reasonable rules, orders, and instructions of the employer. So, one of the fundamental duties ng bilang isang employee is to obey kailangan sundin yung rules and regulations, instructions ng employer. Disobedience to be a just cause for termination must be willful or intentional, willfulness being characterized by a wrongful and perverse mental attitude rendering the employee act inconsistent with proper subordination. So pagka hindi mo siya, yung rules and regulations, pag hindi siya inobey, hindi siya sinunod ng employee, it might cause termination, or the termination must be willful or intentional, dismissal. Termination or dismissal, or the warnings. It depends sa nagawa mong actions sa loob ng company. Willful disobedience of the employer's lawful order as a just cause for dismissal of an employee and envisage, foresees or contemplate the concurrence of at least 2 requisites. So, number 1 is the employee's assumed conduct must have been willful that is characterized by a wrongful and perverse attitude. So, example nito is yung failure to render service during overtime when required and necessary. So, failure to render service during overtime when required and necessary. So, parang ano siya, hindi mo ginawa yung bagay na yun kasi overtime na, and kahit required and kailangan siya, hindi mo siya ginawa. So, next is, the order violated must have been reasonable, lawful, made known to the employees, and must pertain to the duties which he had been engaged to discharge. So, example is not following the orders in the memorandum. So, kailangan daw yung pag violate mo yung order or yung rules na yun, dapat may reasonable explanations, willful disobedience of lawful orders of the superior. So, ay ginawa mong, di mo sinunod yung orders from the superior. Gross, habitual, and neglect of duties. Another ground for terminating employees is gross and habitual neglect of duties. So, to be a ground for dismissal, under Article 297 of the Labor Code, it must be both gross and habitual. So, what is gross negligence? Gross negligence, it is refers to a severe lack of care or reckless disregard for the safety and well-being of others, which is goes beyond ordinary negligence. It involves conscious and voluntary disregard for the need to exercise reasonable care, resulting in serious harm or damage. So, example is the gross negligence may include a doctor performing a surgery while under the influence of drugs. So, pwede siyang maging cause ng malpractice and maaaring makasuhan yung doctor and maaaring mas madadagan pa yung kaso niya kasi ma-influence siya ng drugs. So, a company ignoring safety regulations leading to a workplace accident. So, ayun, parang in-ignore na lang ng company yung ganyung pangyayari. So, this might lead to a workplace accident or a driver recklessly speeding through a residential area resulting in pedestrian injury. So, ayun din, katulad isang example pa is yung sa driver na mabilis na nagmamaneho. So, may mga siyempre pedestrian din, tatawid sila yung mga tao doon. Then, siyempre, hindi in-ignore nila yung ganung mga pangyayari. In legal context, gross negligence is generally viewed with more severity than ordinary negligence. And those found guilty of gross negligence may face harsher penalties or liabilities. Katulad sa doktor na nagperform while under the influence of drugs. So, mas mataas yung magiging kaso niya, mas malaki yung magiging kaso niya. And then din sa driver na nagre-recklessly speeding through a residential area. So, mas mataas and mas malaki yung magiging kaso niya. Then, sa habitual negligence entails a recurring pattern of failing to uphold responsibilities or exercise reasonable care over time. It involves repeated instances where an individual or entity consistently disregard the duties, often resulting in harm, damage, or loss. So, key aspects, it includes the repetition of negligent behavior, awareness of responsibilities, the impact on others or property, failure to correct despite warning, and foreseeability of consequences. Addressing habitual negligence typically requires the intervention such as additional training or disciplinary actions to rectify the behavior and prevent further harm. So, para ma-prevent yung mga ganung harm, it must be, kailangan may trainings and disciplinary actions na pwedeng gawin sa isang company. Fraud or willful breach by the employee of the trust reposed in him or loss of trust and confidence. Article 297 of the Labor Code prescribes two separate distinct grounds for termination of employment. Namely, number 1 is fraud, and number 2 is willful breach by the employee of trust reposed in his employer or duly authorized representatives. Commission of crime or offense by the employee against the person of his employer and immediate member of his family or his duty authorized representatives. So, an employee may be terminated if an employee committed a crime or offense against any of the following. So, pwede siyang matanggal yung employee na to if he committed a crime or offense against any of his following: his employer, immediate member of the family of the employer, yung pamilya niya, or duly authorized representative of the employer. So, parang yung duly authorized, yung hindi pa, nagpakilala siya ng peking employer para lang makapasok siya sa company.
And additionally, sa sinabi ni Julio, other analogous causes may implication na enumeration in Article 282 are not exclusive. So, it is not exclusive pa rin dahil ang mga employee ay pwede pa rin ma-terminated kahit wala sa mga nabanggit. Basta similar or connected ay pwedeng ma-terminate ang employee. In procedural requirements of dismissal of employees be observed. So, in order to validly dismiss o tanggalin ang isang empleyado, mahalaga na sundin ng isang employee ang parehong substantive at procedural due process. Ang termination ng isang employer ay dapat base sa authorized cause, and dismissal ay magkakaroon lang ng effect after ng due notice and hearing. Here in procedural requirements, if the cause of termination is any of the just causes, for termination daw of employment based on just causes are enumerated in Article 297 of the Labor Code. The following procedure must be observed: notice, answer and hearing, and the decision to dismiss. So, the first one is notice. In notice, the law requires ang employer ay magbibigay ng 2 notice sa employee, 1. Specifying the ground or ano yung batayan for his or her termination, and pagbibigay sa employee ng opportunity to explain within his side. And another thing is to indicate that upon due consideration of all the circumstances. The second is answer and hearing. The worker may answer dapat sa allegation against him na nakalagay sa notice within period na tinanggap niya yung notice na yon, the period of 5 days. Dapat rin na ang isang employee na matatanggal ay papakinggan at hahayaan na sasabihin ang kanyang saloobin, syempre sa tulong rin ng assistance of his representative. Dito naman sa decision to dismiss, ang responsibility ng isang employer ay dapat agad na abisuduhin or abisuhan ang employee in writing of a decision to dismiss him, stating clearly and the reasons. Additionally, kapag daw ang employer ay hindi nasunod ang procedure, it may hold the employer liable for damages. Ibig sabihin ay maaaring managot ang employer. In connected with case of Agabon versus NLRC, inuutos ng Supreme Court sa employer na bayaran ng empleyado na na-dismiss sa trabaho ng amount of 30,000 pesos dahil sa for failure to observe the procedural requirements above. In preventive suspension, sinasabi dito na the employer may place the worker concerned under preventive suspension of his continued employment possess a serious and imminent threat to the life or property of the employer or of his co-workers. A preventive suspension is an option that an employer can use to protect the company, its properties, and other resources. In preventive suspension, yung concerned naman ng employee dito ay ilalagay under preventive suspension kung ito ay patuloy pa rin na nagtatrabaho na pwedeng magdulot ng banta or threat sa buhay or property ng employer or his co-workers. The period of preventive suspension shall not be longer than 30 days. Authorized causes. Article 298 permits the employer to terminate the employee even if the latter did not commit any wrongful act provided any of the following circumstances are present. 1. A dismissal based on just cause means na ang employee ay nakagawa ng wrongdoings, while a dismissal based on authorized cause naman, ibig sabihin that there exists a ground which the law itself authorizes to be invoked to justify the termination of an employee even hindi siya nakagawa ng crime or wrongful actions. Halimbawa nito ay ang mga installation of labor-saving devices or ito yung mga appliances, redundancy or occurs when 2 or more employees are performing the same work, retrenchment to prevent losses. Ito yung kapag nire-review ng employer ang needs ng business or company, and then kapag nakitang nalulugi na sila, pwedeng maging way ang pagbawas ng employee para umangat at maging profitable, which is hindi naman kasalanan yon ng isang employee. For the 4th and 5th, closure or cessation of business in good faith. So, dito naman, yung kapag isasara na ang business dahil na, for example, nalulugi na sila, pero sa pagsasara nito, like, in good faith pa rin, which is nakukuha pa rin ng employee ang interest na nila. And the 5th one is, in addition, Article 299 provides that an employer would be authorized to terminate the services of an employee found to be suffering from any disease. Siyempre, hindi naman hahayaan ng employer na patuloy pa rin mag-work ang isang employee na may mahina ng health condition or disease. Basta, if the employee continued employment is prohibited by law or is just prejudicial to his health or to the health of his fellow employees. Compensation for rest day. Ito naman is about sa rest day na kapag ikaw ay pumasok during your rest day, the employer will pay you daily wage of 100% and additional sum of at least 30% of your regular daily wage. Termination of employee or the resignation. The resignation is a voluntary act of an employee who finds himself in a situation where he believes that personal reasons can't be sacrificed in favor of the exigency of the service, then he has no longer choice but to disassociate himself from his employment. Alam naman natin na ito na kapag di na-feel ng isang employee yung environment ng company or yung business na ginagagalawan nila, is magre-resign talaga. And also kapag over din pinapagawa sa yung trabaho, pwede rin personal reasons sa isang employee ang dahilan like mag-a-abroad or mag-focus sa family yung nagiging mga reasons kung bakit sila nagre-resign or nagfa-file ng resignation. If the employer forced the employee to resign or when the employer exerted undue influence against the employee in order for the latter to tender his resignation, then the case for illegal dismissal may prosper. So, this happens sometime when HR or the Human Resource Management told you that you are qualified in unemployment. Maybe nakikita ka ng may poor performance na or just nakikita nilang nahihirapan ka. But in this scenario, this is an illegal dismissal. Why? Ibig sabihin, walang just or batas na sinusunod about dito. For additional information, the law requires na kapag nag-resign ang isang employee, dapat advance 1 month bago niya ibigay ang resignation notice or letter. Hindi rin naman ipinagbabawal ng law kapag natanggap yung notice na shorter or longer than what is provided by the labor code. Similarly, the employer may provide a different notice period in the employment contract, but the employee must be aware of and consent to such a period. Kapag ang isang employee ay hindi pumayag sa time na ibinigay sa kanya, the employer cannot impose a different notice period upon them since an unilateral modification of the notice period is not allowed. Lagi natin tatandaan ang contract about labor ay tinikilala ng batas bilang pure personal, and kung ano man yung napagkasunduan ay dapat may pahintulot palagi ng both parties. An employee may put an end to the relationship without serving any notice on the employer for any of the following just causes. So, pwede dito agad-agaran na ma-end ang work ng isang employee kahit wala ng any notice kapag, Una, serious insult by the employer or his representative on the honor and person of the employee. The second, inhuman and unbearable treatment accorded the employee by the employer or his representative. The third one is commission of a crime or offense by the employee or his representative against the person, the employee, or any of the immediate members of his family. And fourth one, other causes analogous to any of the foregoing.